Talk Radio.
KDWN News Time, 9 o'clock. For 20 years, Brian A. Lowe and Associates have helped Las Vegas locals protect against foreclosure and file Chapter 7 and 13 bankruptcy. If you're in trouble, call 259-0002. Good morning. I'm John Schaefer with this hour's top stories. The Supreme Court is raising the prospect that it will find a way out of the case over California's ban on same-sex marriage without issuing a substantial ruling on whether gays have a right to marry. Several justices, including some liberals who seem open to gay marriage, raised doubts today that the case is properly before them. Justice Anthony Kennedy, the potentially decisive vote on a closely divided court, suggested that the court could dismiss the case with no ruling at all. While the court hears arguments from both sides, the nation's clergy are divided about the issue of gay marriage.
The Reverend Gary Hall, Dean of Washington National Cathedral, says his Episcopal diocese performs gay marriages.
I believe that's a good and holy thing for the church to be doing.
But the Reverend Bill Owens, founder of the Coalition of African American Pastors, says,
no way can that be implied in the Bible.
He says marriage should provide children with a mother and a father. Owens and Hall both plan to be outside the Supreme Court as the arguments are presented inside. Steve Coleman, Washington.
One person is dead, a second critically injured after a second wrong-way head-on collision on the 95 at as many days. This morning, a driver going the wrong way on 95 southbound hit another vehicle head-on at Auto Show Drive.
We had several witnesses, yes, to the scene. We're still making contact with them, trying to piece this together as to why the vehicle was traveling wrong way.
Nevada Highway Patrol Trooper Jeremy Elliott says the driver of the car, a man in his 20s, was killed. The driver of the car he hit, a 25-year-old male, was taken to UMC in critical condition. A special legislative committee is ready to consider whether an embattled colleague is fit to serve in the Nevada legislature. The Assembly Select Committee meets tonight to hear evidence and weigh whether Assemblyman Stephen Brooks should be expelled or allowed to resume serving his district. The recommendation will then go to the full Assembly. No Nevada legislator has ever been expelled. Tax protections that the Nevada mining industry has enjoyed since statehood will be under the microscope as a Senate committee today hears a measure to repeal them. The Constitution imposes a 5% cap on net proceeds paid by mines. Net proceeds are calculated after the cost of mineral extraction and other expenses are deducted. The financial report brought to you by Las Vegas jewelry and coin buyers. On Wall Street, the Dow is up 88 points. Gold is at $1,600 an ounce. Silver, $28.72. Platinum, $15.59. And palladium, $755.50. For questions about your precious metal or coins, call 547-1670. The news brought to you by LasVegasHelpWanted.com. Can't find dependable employees? No problem with LasVegasHelpWanted.com. Get unlimited words for 30 days for only $185. LasVegasHelpWanted.com. Long name, amazing results. It's 9:02. Here's Mitch Kelly with the latest from the KDON 1 Nevada Credit Union Traffic Center.
This report brought to you by the City of Las Vegas. City of Las Vegas part-time maintenance staff are working weekends to make sure you have a clean environment at any one of our reservable city parks. Visit LasVegasNevada.gov/YourCityWorks to learn more about how your city works for you. Got a new wreck at the bottom of the Sahara off-ramp from 15 northbound. It's off on the right side, though, so it's having minimal impact. No Valley Freeway slowdowns right now, but a couple of accidents just off the freeways. One on northbound Durango at Summerlin Parkway. The other on northbound, make it southbound Jones, approaching the 215 Northern Beltway. And a reminder, until 7 o'clock Friday night, State Route 158, the Deer Creek Highway is shut down from the Deer Creek picnic area to State Route 156, Lee Canyon Road. Work crews are cutting into the face of the mountain to create sight lines between oncoming traffic and the nearby Deer Creek picnic area parking lot, which is being expanded and widened. Both the picnic area and State Route 156, though, are open. From the KDON 1 Nevada Credit Union Traffic Center, it's Mitch Kelly on News Talk 720 KDWN.
The KDWN forecast, partly cloudy, 83 the high today, partly cloudy, 59 overnight, then partly cloudy Wednesday and a high of 81. Right now, cloudy, 72 in Las Vegas. Your next update at 9:30 or when news breaks, and we're always streaming online at KDWN.com, brought to you by Brian A. Lowe and Associates. I'm John Schaefer, News Talk 720 KDWN.
Hi, this is Ken Thompson from SportsX Radio, inviting you to join me each and every night, Monday through Friday, 7 to 9 p.m., right here, 50,000 watt AM 720 KDWN, for the greatest in sports talk, breaking down all the games. SportsX Radio, Monday through Friday, 7 to 9 p.m., sponsored by Canna Racing Sportsbooks.
Are you missing one or more teeth and wondering, what are my options? Or do you wear dentures and wish for a more permanent solution? Then this message is for you. Dr. Matashmi of Albright Dental invites you to a free dental implant seminar, 5:30 p.m. Wednesday, March 27th. Dr. Matashmi will share with you the many options available today, including implant-supported dentures or partials and single-tooth replacement implants. All seminar attendees qualify for free sedation with their implant procedure. RSVP today. Call 714-0998, 714-0998.
Alan Stock here. Hey, catch my friends John Burnett and Elisa Grassi on Daybreak Vegas at 5 a.m. right here on KDON, where no subject is out of bounds.
No matter what kind of smartphone you've got, iPhone, Android, BlackBerry, Nokia, you can take News Talk 720 KDWN with you anywhere. Download the free TuneIn app from your phone or tablet's app store. Tune in with music, sports, news, and comedy from over 70,000 stations around the world, including KDWN. Get more info at tunein.com or KDWN.com. We go where you go. Download TuneIn from your app store for free. News Talk 720 KDWN, where locals come to talk. The broadcast of information on this show does not create an attorney-client relationship with any of the listeners. Communication between the listener and the hosts of this show will not be confidential. The information provided on this show is prepared for a general audience without investigation into the facts of each particular case and is not to be considered legal advice. The information provided on this show should not be used as a substitute for legal advice. The listener is advised to consult with a qualified attorney on any legal issue they may have. It's time for News Talk 720 KDWN's Legal Hour. Have a legal question? Call now, 257-KDWN. That's 257-5396.
KDWN News Time, 9:06. Good morning and welcome to the Tuesday edition of the KDON Legal Hour. 257-5396, the number to call if you have comments or questions. This morning for attorney Airene Williamson from the Williamson Law Office. Good morning, Airene.
Good morning, Jen. It's great to be here in our Tuesday Legal Hour.
And this week, we will continue what we were discussing last week. We have been discussing employment law.
Right. And I think last week we talked about social media and wrongful termination. And this week we're going to talk about restrictions on competition and what they call covenants not to compete. And we'll talk about a little bit of wrongful termination, primarily because I've gotten a lot of calls on it off the air. And I just want to emphasize some of the points on that. And lastly, FMLA section or Family Medical Leave Act. A lot of people have questions on that, and unemployment. So if anybody has any questions on that, you can call the show or call my office, Williamson Law Office, 702-608-4072.
And if you want to get it answered here, 257-5396. All right, let's start with what we just generically like to call non-compete agreements. A lot of people might not be familiar with that, but everybody that works in the media is.
Right. And actually, it's increasing in a lot of areas and industries, primarily because we're moving into this technological arena in a lot of businesses. They're using a lot more confidential information, a lot of trade secrets, maybe some trademarks or copyrights involved in their businesses. And it's getting more and more common in the business arena. Basically, I think a lot of people know covenants not to compete are agreements between an employer and employee not to compete or enter into a business competition with the employer during the employment, obviously, and shortly thereafter, the termination of the employee. Now, this is usually negotiated between the employer and employee primarily before the employment or right after. They usually negotiate that the employee cannot compete with or cannot be employed by a business competitor, or any information that they've garnered during their employment, or any skills that they have gained, or any information, trade crafts that they have learned from the employment. They cannot use that in competition with the employer. And non-compete agreements are primarily, they are governed by state laws, and they are very different in different states. And I always tell my employer clients that if they, just stop using those form non-compete agreements that they find in the internet, primarily because we have, especially if they have, employees in different jurisdictions, right. California, Nevada, or Colorado and Utah, if they have those businesses, they are different. For example, in California, actually, non-compete agreements are unenforceable unless there's a partnership agreement, dissolution, or some stock sales, or just closing down a business. But primarily, it's not enforceable in California, but in Nevada, it is in some areas.
That was going to be my next question. What are those areas? Because let's start first. We'll start with what you're talking about, because I work for a company that has its main headquarters is not in Nevada, and we have stations all over the country. But I think we do all sign the same generic contract,
right? Which I think is not a good idea. But if you want to be able to draft your non-compete agreements in conformity with the case laws of Nevada. For Nevada, it is generally enforceable. As long as in two factors that are considered enforceable. And one is that there has to be a consideration when you enter into non-compete agreements. Basically, that's money or continued employment. And number two, which is the most disputed or the crux of a lot of issues in non-compete, which is reasonability. And, in a lot of cases when it comes to reasonability, attorneys have a heyday on it because we have all different interpretations of what reasonable is. But we do have primarily a lot of case laws in Nevada that interpret what reasonable is. And in Nevada, there's a lot of factors that you have to consider whether it's reasonable. And number one is the amount of time. Is it 5 years? You cannot go outside of your employer. Well, we have a Nevada case law that says 5 years is way too long. It's not reasonable. So the amount of time is number one. Number two is territory that it covers. What is the geographic location? So when you're negotiating with your employer on your non-compete, you have to ask, well, which area can I compete after you terminate me or after this project is done or my employment is done? We have a case in Nevada wherein this business owner basically have a non-compete agreement in Sparks, Nevada. That is where the only business is located. They don't have any clients anywhere else, but it prohibited the employee from competing in Reno or in Las Vegas. And in fact, it actually included California. And the court said, no, you can't do that. You're only a Sparks, Nevada company. So your geographical location is way too big. And the other, of course, is hardship. Is it going to cause hardship to the employee? Does it restrict him completely from competing with other business or gaining employment from another employer?
With the times like they are and have been the past couple of years in the economy where unemployment is high and it's hard for people just to get a job in general, and a lot of people were being let go or laid off.
Right.
Many of these people might have had non-competes. Would that make it easier for a court to say that's not enforceable because it is too hard at this time to get a job? So the fact you were even able to find a job after being let go, you're allowed to get out of it.
It definitely, exactly. That's one of the hardship tests of the non-compete agreements, especially in the economic times we have today. They have to consider, especially if it's a specialized trade, that there's not a lot of employers employing their skills. That's going to be considered in the hardship test. If it's something that only a few employers in town hiring them for that specialized skills, we cannot have a lot of restrictions on those non-compete agreements. So, a lot of employees do not have a lot of leverage at this point in negotiating with the non-compete agreements. But basically, hardship is you got to look at the factors of geographic location, how specialized it is. You cannot have a non-compete agreement on lower-level employees. For example, if it's a landscaper, you cannot make the landscaper sign a non-compete agreement. Obviously, that's unreasonable. We're talking about higher level. We're talking about employees that have information or access to confidential proprietary information. So those are the reasonable tests that we're talking about.
Right. Something that another business would be willing to come after you to get.
Exactly. Something that has economic value. And one of them is customer list. If you're an estimator for a company, if you're a salesperson for another company, especially at high level, wherein when you get employed, you get given in this spreadsheet of employment information and client information with all this contact information. I think that's very valuable, and that should be protected under reasonable limits.
When you're negotiating your contract, are these things that can all be negotiated with your employer, or do you pretty much have to take what they give you?
Well, in this economic times, I would have to say you don't have a lot of leverage. But if it's a highly specialized employment situation where there's not a lot of employees that are qualified to do the things that you require them to do, employees actually have some leverage. They can negotiate. If you think it's a little bit restrictive, you can negotiate a severance pay. Obviously, if the employer thinks that it's important enough for non-compete agreements, it might be important enough for a severance pay, especially if they are restricting you for 2 years. A lot of the non-compete agreements I've seen that are been upheld to be reasonable is non-compete agreements for 2 years and geographic location of 50 miles. That has been upheld to be reasonable.
Well, yeah, that seems reasonable here because once you're 50 miles away from Las Vegas, you're in the middle of the desert, so you're not going to be
either you're in
competing.
California or in Utah, so that's 50 miles for Las Vegas. That's what I've seen that are reasonable in non-compete agreements.
So I've got a non-compete. I leave here and decide I'm going across the street to work anyway.
Right.
What can happen to me?
Well, two things that can, first of all, you got to see, is the non-compete agreement enforceable? If the court says, okay, it's reasonable, it's valid, you probably couldn't just work for anybody else. So there's a lot of repercussions when you violate your non-compete agreements. It's number one, they can obviously sue you for an injunction not to work for that employer, and they can go after you for monetary damages. And by the time that that case is done, you've spent all this money and you can't work at the same time. So you got to be careful when you do that. So that's number one, repercussion of violating a non-compete agreement. Number two is they could actually go after the new employer that you are now working for. It's a little bit different in a lot of case laws because in a lot of cases, you can't really go after the third party who's not a party to the agreement. But in this case, the court said, well, if we can't enforce these non-compete agreements against a new employer, then it doesn't have a lot of teeth. So in this one, we're going to enforce it against a third-party employer. In fact, there's a Nevada case law wherein the third-party employer or the new employer is found to be knowingly abetting in stealing the customer information from the new employee, and they have basically co-conspired in using that customer list in gaining more business. And the court said, we're going for money damages after you as well. So you got to be, if you are the new employer and you think your employee has some proprietary information or confidential information, check out first if they have restrictive covenants that are currently enforceable. Most likely they are, and if they do, they can go after you for that.
All right, we will be back with attorney Airene Williamson right after we check in with Mitch Kelly in the KDON 1 Nevada Credit Union Traffic Center.
This update at 9:16 brought to you by Constant Contact. Want your marketing plan to be as stress-free as the open road? Email marketing from Constant Contact's an easy-to-use tool that helps you to reach your customers in a place they're checking every day, their inbox. Sign up for a free trial from the industry-leading provider at ConstantContact.com. Crash still being cleaned up at the bottom of the Sahara off-ramp from 15 northbound. It's on the right shoulder and not causing really any delay. Northbound Durango at Summerlin Parkway, southbound Jones approaching the 215 Northern Beltway. A pair of injury accidents that are still being cleaned up. Overall, though, very quiet conditions on the roads right now. Have another update at 9:30. And from the KDON 1 Nevada Credit Union Traffic Center, it's Mitch Kelly on News Talk 720 KDWN.
If you have a problem with your teeth and you don't know what to do, pick up the phone and call AQ. AQ Denture and Implant Center has helped over 25,000 people in the Las Vegas and Henderson areas with affordable quality dental service since 1975. I'm Jim Dallas of Beasley Broadcasting. Dr. Mira Kandia helped me smile again, and he can do the same for you this summer. Whether you need crowns, bridges, dental implants, or an extreme dental makeover, call 565-6000. That's 565-6000 for AQ Denture. Smile again with confidence.
I'm Harry Jacobs, CEO of Credit Restoration in Nevada. And I've got to tell you, I really love my LASIK from LASIK of Nevada. I was just plain tired of dealing with glasses, and I had trouble reading the fine print on credit reports, and I wanted the best quality for the best price. And it takes less than a minute per eye to see the world like you've never seen it before. That's the amazing thing about the LASIK procedure. And the all-laser LASIK procedure at LASIK in Nevada can be safer and more comfortable than ever before. Here's how LASIK can change your life, too.
To wake up and not have to put in my contacts or put in my glasses. Just wake up and see my husband in the morning, see my kids. I had to lay in bed for like 10, 15 minutes, just look around my room. It's like, wow.
I would recommend it to anybody. It's awesome. I watched tons of videos online and it was just great. There's no pain involved. You're in and out within 15 minutes, both eyes, and you're walking out of there seeing clear.
So call LASIK in Nevada at 636-2010 right now for your free consultation, and you'll get 50% off premium LASIK. Call 636-2010 or visit LASIKofNV.com today.
Now back to KDWN's Legal Hour. Have a legal question? Call now. 257-KDWN. That's 257-5396.
KDWN News Time 9:18. Welcome back to the KDON Legal Hour with attorney Airene Williamson from the Williamson Law Office. 257-5396 if you have a comment or question for Airene as we discuss employment law. We just covered non-compete agreements. Anything you want to add to wrap that up before we move on?
Yeah, just a couple of things. And one of it is a lot of my clients ask me, well, I found this great new employer and can I get out of it? And the answer is, like I said earlier, if it's valid and enforceable, usually you cannot get out of it. Now, what happens when the court says it's unreasonable or is it too limiting? It doesn't completely invalidate the restrictive covenant, or what you call a covenant not to compete. What the court will do is instead of 5 years, they will slash it to 2 years, and they will slash the geographical location. So don't count on the courts to completely render the restrictive covenant to be invalid. So just keep that in mind. And basically, when you do your covenants not to compete, you have to be careful what you're signing, just like anything else, especially when you think your trade skills are highly specific. And no employer will, or a lot of especially in Nevada, we don't have a lot of tech companies here, and we don't have a lot of employers that are tech companies here. So you got to be careful what you sign.
All right. Wrongful termination.
Right. We discussed some of that last week, and for some reason, I've gotten a lot of emails, off the air and a lot of calls off the air, and I'd like to touch on that today. Basically, wrongful termination, and a lot of people are asking, what are the exceptions to at-will employment? Well, wrongful termination, first of all, in Nevada is based on federal law, Fair Labor Standards Act, and we obviously have the Civil Rights Act. And those are wrongful termination or any termination that are violative of public policies. They terminate you for discriminatory grounds, either gender or religion and race. Those are pretty common and obvious. Any termination with regards to public policy, and that's termination on workers' compensation, FMLA leave, which we'll discuss in a bit. Any termination that, for example, they terminate you because you reported them on illegal activity. We've covered that last time. Another thing that I don't think people realize is that not all employments are at-will employments. Number 2 exception to the at-will employment is the fact that if it's a term employment, either express in a contract, okay, you are in a project, you have 1 year to finish this project, that's your term. They cannot terminate you on that unless there's some good grounds for termination, but it's not an at-will. They have to have good cause to terminate you in a term employment. And another thing is promissory estoppel. And it's a mouthful for a lot of people, but basically a lot of people, for example, in California, they entice you to come here. An employer comes to you and say, I want you to work for me. Mm-hmm. I will pay your moving costs. You come here, I will pay you this much, and you quit your job and you work for me. Promissory estoppel means you've relied on that promise. You basically spent money. Well, sometimes they pay for moving costs, but you spent the money. Not only have you spent the money in moving and boxing, but you've also quit your job. And once you get here, you find out they don't want you anymore. So on those grounds, that's what I call a promissory estoppel, and that's an exception to the at-will employment. So there are exceptions to the at-will employment that people will have to keep that in mind.
We have a lot of union employees in this town, especially the culinary union. A lot of people that work for resorts are in unions. Is there any difference between being a union employee and a non-union employee when it comes to at-will and wrongful termination?
Absolutely not. Obviously, they are under different contract agreements and labor agreements, but as far as at-will employment, they can be terminated. Now, as far as procedures of termination, they might have additional protections, they might have additional due process protections, such as warnings and notices, which in a regular business anyway, you should implement anyway, because that's just good business sense. And that's, for example, if you think you are not getting along with your employee, then you just make sure that you do a review that either quarterly basis that is in writing, and that you have some supervisor with you when you're an employer, another supervisor supervising the meeting and making sure everything is in writing and in a policy or in a handbook. Everything has to be just so, because one of the criteria of a wrongful termination is if you're discriminating against employees, and we're not just talking about race, but if you're implementing regulations differently for each individual employees, you are not implementing them uniformly. That could be termed as discriminatory.
Right, and I would imagine that if you were an employee and your employer fired you and you didn't think that you have done anything wrong and your performance has been good, maybe it is just your employer doesn't like you, but there are a lot of things you can come up with for a reason that they're discriminating. They fired you because they're discriminating against you.
Right, and that's what makes wrongful termination so difficult to prove, is that basically you're not an at-will employee. They can terminate you for any reason or no reason at all. And so, but what we call circumstantial evidence is that a lot of wrongful termination will be based on proving it. It will be based on circumstantial evidence. What has been happening in the last 6 months that hasn't happened when you were terminated? Have they treated you differently? You have a good performance, but now you've filed for workers' comp and suddenly you have a bad performance? You got to look at the circumstances. You got to talk to an attorney, frankly, because this is such a hard case to prove in a wrongful termination.
I've done nothing. I am a model employee, and now just all of a sudden I have been let go. Should I seek out an attorney's advice for something like that? Because I feel it was wrongful.
That depends.
I don't think I'm being discriminated against, but I don't understand why. I mean, I haven't had any bad reviews.
Right.
I do my job.
Actually, in most states, not in Nevada, but in most states, an employer is required to give you in writing the reasons for terminating you. In Nevada, unfortunately, we don't have that, but you can request something in writing and why they terminated you, and most of the time the employer will give you a writing or reason in writing, just because they want to cover all their bases and make sure that if you do go to a complaint or EEOC or Equal Employment Office for a complaint, then they can cover their grounds and say, well, these are the reasons, these are the backup documents, you have actually performed poorly, which may or may not be true, but they will give some reason to do that. So if you just ask your employer for a reason, most likely they will. And I think when you do a wrongful termination case, a lot of people think that you can just go directly straight to the court and file a complaint. That's not how it works. And I always advise clients, either employer or employee, in a wrongful termination case, and we've talked about it last week, is there's a lot of statute of limitations differences. It's confusing, and I actually have a chart of statute of limitations depending on what the reason is for terminating you. If it's terminating you because you filed an OSHA complaint, or terminating you because you filed a complaint for labor and hour or wage issue, or what. An OSHA complaint, actually, you have to bring that complaint within 30 days, for example. If it's a discrimination ground, you have to bring it with the EEOC in 180 days. If it's labor and wage, it's 2 years. So it's different for different reasons, and you got to be careful when you do that. And another thing that's required for wrongful termination is you got to go to the agency first, file an administrative complaint, and after their investigation and they're found that they're not liable or what have you, then they can go and appeal in court.
What is a constructive discharge? You've done a good job, but you're fired. There, that was constructive, and I've discharged you.
Well, that's not constructive discharge. Constructive discharge is actually more common than an outright firing, especially when the employer is a lot more careful when it comes to firing you. Constructive discharge is basically when they do something during the course of your employment that changes, for example, that makes you quit. They basically force you to quit, which is actually a wrongful termination in a roundabout way. But you can't say, well, how many employers will say, I'm firing you because of your race? Nobody will say that.
Right.
Or I'm firing you because you filed for a workers' compensation claim. They will not say that, but they will make your life so miserable. Either they inundate you with poor performance reviews, which happens a lot, or they transfer you to a different location. They give you a lot more work than what's agreed, or those are kind of circumstances. And when those have become the change is such that the employee is forced to quit. And one of the tests is that the employee actually negotiates or come into the table and tell the employer, this is not what we've talked about. There's some conversation with them and it still hasn't changed. Then that's constructive discharge in a lot of states, including Nevada.
Do a lot of employers use the constructive discharge as a way to get out of the employee being able to collect unemployment because they haven't been terminated? They quit on their own. Right.
Unemployment, and that's one of the topics that I want to talk about. It's unemployment. Unemployment, you are entitled to unemployment if, I think a lot of people think that maybe when you're only laid off, that's when you are entitled to unemployment, but not so. Even if you have a poor performance review, you will actually be entitled to some unemployment compensation depending on what has happened. The only time that you're not entitled to an unemployment is when you've done a misconduct. You've done an action that is so egregious that is adverse to your employer interests, and this is kind of a blurry line between misconduct and poor performance. If you're excessive tardiness or you just don't show up at all, they might consider that as misconduct, and you may not be entitled to unemployment. But basically, the only time that you are entitled to unemployment when you quit voluntarily is when you have good cause. Good cause means either the working environment, for example, is so hostile. That's one of the constructive discharge that we're talking about. If this hostile environment is so unreasonable that you're forced to quit, then you can be entitled to unemployment.
All right, we will continue with this with attorney Airene Williamson. 257-5396. Get your calls and questions ready. Give us a call. Airene can answer your questions right here, right after we check in with news, traffic, and weather on News Talk 720 KDWN.
If you would like quality diamonds at exceptional prices, then come to Tom Tutman's Diamond Mine. If you would like sparkling 2-carat Marquise cuts for only $49, then come to Tom Tutman's Diamond Mine. If you would like the personal service you've come to expect from Tom Tutman himself, then do not come to Tom Tutman's Diamond Mine, because Tom Tutman passed away last week at the age of 47, leaving his wife and 3 children, struck down in his prime by the same disease that got his father, so he won't be around to care for his family. And the sad part is, it all could have been detected early with a simple test. But Tom didn't get it.
Have you gotten the medical tests you need? For a list of tests every man should have, go to ahrq.gov. Once again, that's ahrq.gov. A public service announcement brought to you by the U.S. Department of Health and Human Services and the Ad Council.
50,000 watts of news and talk. News Talk 720 KDWN, Las Vegas, the dawn of today's talk radio.
AP Update. I'm Rita Foley. The Supreme Court has just heard oral arguments in the case involving California's ban on same-sex marriage. Several of the justices raised doubts about whether the case is properly before them, the suggestion being that the court could try to find a way out of the case without issuing a major ruling that would affect the rest of the nation. The 2 gay couples who brought the case stepped outside the Supreme Court building following the arguments.
Hi, my name is Paul Katami, and for me, from the beginning, this case has been about securing the right to marry the person that I love.
Hello, I'm Jeff Cirillo. We are so pleased to have had this opportunity to present our case to the United States Supreme Court today.
Hi, I'm Sandy Steer, and I, like all Americans, I believe in equality. I'm Chris Perry, plaintiff in the case just heard in the Supreme Court.
Inside the courtroom, Justice Kennedy said he feared the court would go into uncharted waters if it embraced arguments advanced by gay marriage supporters. I'm Rita Foley.
9:32 in the KDON 1 Nevada Credit Union Traffic Center with an update brought to you by the Four Queens Hotel and Casino. Pretty quiet on the Valley freeways right now. Just off of the Sahara off-ramp from 15 northbound, you'll find crews clearing an accident at the bottom of that off-ramp. All lanes are open. New injury accident on the west side, Jones at Vegas Drive. Leftover wreck still being cleaned up. Southbound Jones approaching the 215 Northern Beltway and northbound Durango at Summerlin Parkway. KDWN weather, a lot of clouds, breezy this afternoon, too, with a high of 82. Currently at 60 degrees in Las Vegas. And more of the KDON Legal Hour with attorney Airene Williamson's coming up. From the KDON 1 Nevada Credit Union Traffic Center, I'm Mitch Kelly on News Talk 720 KDWN.
Get hammered with the Mike Hammer Comedy Magic Show at the Four Queens Hotel and Casino. Every show is loaded with audience participation, and nobody is safe. Tickets are on sale now at fourqueens.com or at the Four Queens box office.
Hi, this is Doug Basham. You know, the guy you just can't get enough of. Or is that the guy you just love to hate? In either case, join me every Saturday afternoon at 3 for something a bit different. That's Saturday afternoons at 3 p.m. See you then.
First Option Mortgage, the people you call first.
It's the final hours. Insurance rates on many government-backed loans are going up at midnight on Sunday. These increases will cost some homeowners tens of thousands of dollars over the life of the loan. Call First Option Mortgage now and lock in before the higher rates take effect on Monday. There are no application fees, and since First Option approves their own loans, you'll close fast and pay lower rates. Please don't wait. With mortgage rates at record lows and insurance rates going up at midnight Sunday, the time to call First Option Mortgage is now. First Option Mortgage, 669-5400. 669-5400.
First Option Mortgage, the people you call first.
First Option Mortgage, LLC, 3770 Howard Hughes Parkway, Suite 195, Las Vegas, Nevada, 89169, license 3269.
Don't miss the 4th Annual Green Fest, combined with the 17th Annual Festival of Communities to honor National Earth Day, Saturday, April 20th at the UNLV campus. Admission is free. Learn how to create a more enjoyable and sustainable lifestyle by going green. Visit with over 130 booths, including green vendors, a fun kids zone, live entertainment, food and activities, conservation exhibits, and more. Saturday, April 20th at the UNLV campus, 11 a.m. to 6 p.m. Go to greenfestlv.com for more information. Brought to you by UNLV Green Alliance and Republic Services.
Now back to KDWN's Legal Hour. Have a legal question? Call now. 257-KDWN. That's 257-5396.
KDWN News Time, 9:34. Good morning and welcome back to the Tuesday edition of the KDWN Legal Hour with attorney Airene Williamson from the Williamson Law Office. 257-5396 to join in the conversation, or if you have a comment or question for attorney Williamson, Airene Williamson, Esquire, as we like to refer to you.
Esquire. I haven't heard that in a long time.
As we're wrapping up the wrongful termination part and moving into unemployment and FMLA, pretty much, as we were just talking about, everyone that gets terminated thinks they've been wrongfully terminated.
Right. And, it's never a good time when an employer terminates an employee. It's never an easy decision, but you just have to follow the regulations that is in state and make sure that you are complying with all the regulations of the federal law and the state law in Nevada. And for employers, one step to covering your crossing your T's and dotting your I's is that you have to keep records. And that's really all there is to it. You keep records and you make sure that you treat everybody the same way, and you make sure that the policies of your handbook or the policies of your companies and the goals of your companies are implemented the same way for everyone. And if you just keep that, it doesn't mean that you'll never get sued, but at the very least, you do have a defense for it. And I know a lot of employers that does not have, first of all, I know a lot of employers, especially small business owners, do not have policies for one, which makes it really difficult to say, okay, is this discriminatory? Was it, was the rule enforced arbitrarily? Well, we don't know because we don't have a policy. Or they don't even have a performance review. They do it verbally, and it's just a he said, she said kind of thing, and that's going to be difficult to litigate when it comes to that. And another thing that comes up typically in a termination is the pay. When you terminate somebody, when do you pay them? And the answer to that, and a lot of employers may not know this, you have to pay them all that's due to them on the day that you terminate them. And that seems like a common sense knowledge, but I have a lot of cases that are going in the Department of Labor because they haven't been paid at the time that they were terminated. Or if they quit voluntarily, you have to pay them either in the next paycheck or 7 days after they're terminated. So those are the kind of rules you got to keep your eyes on and make sure that those are implemented. Either you have an HR running your company or an attorney advising you on these matters. In fact, I have a landscaping company that on every termination he calls me just to make sure that everything is covered.
So what happens if I understand because maybe you're going to fire an employee, so you're able to get everything ready to go and have that check there for them. Mm-hmm. But suppose you just decide all of a sudden because of an employee's poor performance or whatever they happen to do at that moment that they've got to go right then, and you fire them on the spot. How are you supposed to have their pay and all of that stuff ready to go?
Well, usually the decision to terminate somebody happens long before that, maybe 24 hours or 48 hours. They will have the check ready. At the latest under the law is 3 days. So you got to give them 3 days at the very least. If not, they can go after you in the Labor Department. And one of the issues on last pay for termination is what if they steal an equipment or they have an equipment on their belonging that they have not returned to you? Can you deduct those on the wages or on the last pay? And the answer is absolutely not. Well, there's some exceptions, but in general, you cannot do that. The only thing that you can deduct are obviously taxes and federal and state taxes that you can deduct under the law, or if the employee agrees in writing that you can deduct certain things, which I've never seen before. So generally, you can't. If you do have a cause of action against that employee, it will have to be in a separate matter. They cannot deduct anything on the final check.
All right, so then you just have to go after them separately to get back whatever it is that they're not returning to you.
Right, which will never happen because they're gone.
Exactly.
By then, and it's not worth it. Usually the equipment is about $50, and you don't really want to go after that. You don't really want to hire an attorney for doing that, but you just want to make sure that. But the problem is you cannot deduct because the liability will probably more on you rather than the employee, because they can go after the Department of Labor. And once you get dinged by the Department of Labor, then you will get audited a lot more times than you want to.
All right, so you've been terminated. It wasn't wrongful. I need to collect unemployment because I don't have another job. How do I go about doing that?
Right, and we've talked about it. We touched on it a little bit earlier. Basically, if you are fired or terminated for poor performance, general poor performance, generally you can collect unemployment. The only time you cannot collect unemployment, again, is misconduct. If it's a theft or the poor performance is so excessive that it's egregious to the employer, like we talked about earlier, excessive tardiness, you just don't show up at work, that they might consider that as misconduct, and they may not qualify you for unemployment. And the other issue is, what if I voluntarily leave the company? Again, the only time, again, it cannot be just a voluntary leave. It has to be good cause. Either for health reasons, you have to quit the job. The only test that's required for a good cause is that you've actually tried to have some reasonable attempt to notify your employer, either, okay, I quit, or we can come to a kind of a reasonable accommodation on what I can do with my situation. One of them is health conditions. That's a good cause. One of them is either a family tragedy and you can't come back to work. They can try to reasonably accommodate you, but it just didn't work. Some sort of that situation. Most likely, a lot of people quit, and because of the harsh working environment, that's definitely, you are still under the unemployment regulations, so you can be entitled to that.
I can't just quit because I'm lazy and decide that I'll make more money sitting at home collecting unemployment than I do at my minimum wage job.
That's a good point, because I think a lot of people probably know some of the criteria and unemployment benefits is, number one, you have to be able to work and are not disabled. And if you're disabled, it's entirely different law will apply ADA. But you have to be able to work. You have to be actively looking for a job. You can't just sit on the couch and not look for a job. And you have to file these weekly certifications, which are now available online, which makes it definitely easier for a lot of employees to do that. Another thing that I think, in my personal opinion, leads to a lot of abuse and unemployment is that the weekly wage allowance cannot be more than what you're getting in unemployment. So a lot of people probably would rather collect unemployment than find a job that's comparable, but you got to pay for gas, you got to pay for childcare. Then it's a lot more than just sitting at home collecting unemployment, which I think is a very, very faulty system. But that's how it is today. If your wage allowance is more than your unemployment, then you're out of unemployment. If it's less, then you're still under unemployment.
And how's it determined how much unemployment I'm going to get?
Well, it depends. It depends. It's actually a very complicated calculation.
Of course it is.
It is. It never is easy. But the good thing about it is they actually have a calculator in the DETR, the Department of Education, Training, Rehabilitation, which oversees the unemployment. So they have a calculator in there. It's really easy. It's really user friendly. How long you've been employed in your current employer, what pay you've been getting paid for the last whatever years, and so based on that, that's going to determine how much you get. It's I believe it's from $16 a week to $362 a week, and for $362 a week is a lot. So you got to make sure that if you think you're entitled to unemployment, you want to be proactive on getting that and see if you can. It helps you out during your unemployment period.
All right, we've got a call for you, Irene. Tony is on the line. Good morning, Tony.
Hi, good morning.
Good morning, Tony.
Hi, how are you?
I'm doing well.
Thanks for taking my call.
Sure.
Hey, I was working for a casino company, Harris,
right,
at the Planet Hollywood, and I did resign. And they have one day pay for me, and almost a year now. So when I talked to payroll, they sent me a letter late to give me 14 days, and I got the letter only 2 days before the 14 days was up. So I couldn't get all the requirements. So end up sending all the paperwork. They said to send it to Treasury, Nevada Treasury. So when I called Nevada Treasury, they said that they don't have anything available for me. So now I called them back, and they told me to send some paperwork on the check date and how much I owed. So I faxed it back. So I don't know what they said they want that for stop payment. So I want to know what I could do to get my money.
Well, first of all, I don't know if you've already gone to the Office of Labor Commissioner, but if they and I don't know the situation of what they paid you, how much they paid you on the last day, but if you think you haven't been paid what's owed and due to you at the last day of your work or within 3 days after you were terminated, you have the right to go to the Office of Labor Commission and file a complaint. Is that where you're at right now?
No, I'm not. I was just listening to your show, and I decided to call.
Because I thought you were talking about some records that you were required to have, so I thought you already filed a complaint. So basically, you file it in the Office of Labor. The sooner, the better. It's been a year, Tony. I think that's what you said. It's been a year. I'm not sure if you're still within the statute of limitation, but you want to make sure you got to go and do that as soon as possible and see if it's actually still within a statute of limitation. But basically, once you file an Office of Labor Commissioner, the investigation starts. They will request more information from you and more information from the employer. And if they find in your favor, they will penalize them and pay you for all the back pays that they haven't paid you plus interest. So that will be the step I will take. It's called the Office of Labor Commissioner.
All right, then. Thank you so much.
Okay, thanks.
Thank you, Tony. 257-5396 if you've got a comment or question for attorney Airene Williamson. We will be back talking a little bit about Family Medical Leave Act, FMLA, once we check in with Mitch Kelly in the KDON 1 Nevada Credit Union Traffic Center.
And this report at 9:45 brought to you by the City of Las Vegas. City of Las Vegas part-time maintenance staff are working weekends to make sure you have a clean environment at any one of our reservable city parks. Visit LasVegasNevada.gov/YourCityWorks to learn more about how your city works for you. Crash still being cleaned up at the bottom of the Sahara off-ramp from 15 northbound. All lanes, though, are open on that ramp. Watch for NHV helping out a stalled driver along the eastbound side of the Southern Beltway at the airport connector. West side injury accidents, Jones at Vegas Drive, northbound Durango at Summerlin Parkway. New one in the downtown area, Carson at Main Street. Also now Martin Luther King at Washington. And a reminder, Sunset closed over a small stretch between Bermuda and Pilot, just across from McCarran Airport. Crews have to do work on the Union Pacific Railroad tracks there, and that closure is going to last until around 5 Thursday afternoon. Your next report's at 10, and from the KDON 1 Nevada Credit Union Traffic Center, it's Mitch Kelly on News Talk 720 KDWN.
Are you missing one or more teeth and wondering, what are my options? Or do you wear dentures and wish for a more permanent solution? Then this message is for you. Dr. Matashmi of Albright Dental invites you to a free dental implant seminar, 5:30 p.m. Wednesday, March 27th. Dr. Matashmi will share with you the many options available today, including implant-supported dentures or partials and single-tooth replacement implants. All seminar attendees qualify for free sedation with their implant procedure. RSVP today, online at albrightsmile.com. That's albrightsmile.com.
Are you tired of fighting with your water, dry skin and hair, dingy laundry, unpleasant tastes and odors, stained sinks and fixtures? Well, now is the time to do something about your water. Hi, Alan Stock here, and I wanted to make sure I had the best water system available, so I called Connecticut over 13 years ago. My clothes are brighter, I see no more hard water stains, and the water is the best I've ever tasted. As a matter of fact, people who visit our home always ask for another glass of that delicious water. And the amazing thing is, we haven't had any service calls to fix our system. Now, the experts at Connecticut Water Systems really know their stuff and can customize a solution that's right for your home and your family. Now, the Connecticut water systems are completely different. They require no electricity, there are no customer adjustments, and they don't use a ton of salt. Connecticut Water Systems also features the longest manufacturer's warranty, and it's designed to last 30 years plus. Your local independent authorized Connecticut dealer wants to make it as easy as possible for you to try clean conditioned water in your home by offering a free trial. Go to kwater.com for more details on their free in-home trial. That's the letter K and the word water. kwater.com, and get your trial started today.
If you're like millions of other Americans, you're wondering if now is the time to purchase a home or refinance the one you already own. You'd love to take advantage of the low interest rates and home prices, but you know it's important to make a responsible decision, and that's where I can help. Hi, I'm Dustin DeHart with Noble Home Loans, and I have both the expertise and available loan programs to get you in the right loan. Did you know there are loan programs out that allow you to refinance at today's low rates without an appraisal? That's right. No matter how upside down you may be in your property, you can refinance today. So call me today to get started at 217-3009. Again, that's 217-3009.
Alan Stock, weekdays 6 a.m. to 9 a.m. only on News Talk 720 KDWN. Free legal advice weekdays from 9 a.m. to 10. Fixing your finances. The Ray Lucia Show. Weekdays 10 a.m. to noon. Rusty Humphreys, noon to 3. Sherry Doyle. Weekdays 3 to 6. Ask the experts. Weekdays from 6 p.m. to 7 p.m. More live local talk than any station in Las Vegas. News Talk 720 KDWN. On the air, on the web, and now on your iPhone and Android. Now back to KDWN's Legal Hour. Have a legal question? Call now. 257-KDWN. That's 257-5396.
KDWN News Time 9:48. Welcome back to the final segment of the KDON Legal Hour with attorney Airene Williamson from the Williamson Law Office. 257-5396 if you'd like to reach Airene here in the studio, or you can give her a call later at her office at 608-4072, or reach her by email at info@wlawoffice.com. Family medical leave. I think there's a lot of confusion with people about that, about what I get, what I don't get.
What you're entitled to, yeah, right. And this is a law that passed in 1993, basically allowing all the eligible employees and all covered employers, and we'll talk about who are the employers that have to follow FMLA, in a bit. But basically, it provides you a right for a 12-week unpaid leave for any instances where you have to either, number one, care for a newborn or newly adopted child. Number two is for a seriously ill family member, and we'll talk about that later. Who the family members are, like spouse and such, and to recover from a worker's own serious illness. And I think where the confusion lies is what is serious health condition. And as we will know a little bit more later, is that the employers actually have the burden to determine whether you are entitled to an FMLA, or if your condition is serious enough that it merits using that FMLA rights. And serious health conditions can run the gamut of either pregnancy, maternity leave, surgeries. Those are the kinds of treatments in hospital or medical facility or continuous treatment in the healthcare providers. Those are what we were calling serious health condition. We're not talking about a cough or a flu for a few days. They're typically not entitled to FMLA.
What if my wife is pregnant, she's having a baby, and I want to stay home for the 12 weeks after she gives birth?
Right.
Am I allowed to do that?
Yes, you are. Technically, you are, even if you are a father. I mean, the problem is society hasn't accepted that quite a bit nowadays, and a lot of employers I know don't allow it. But technically, they're violating the FMLA Act when they do that. You are a father or a mother entitled to a 12-week unpaid leave, but on pregnancy instances, you have to take it all at once. You cannot take it intermittently. You have to take the whole 12 weeks unpaid leave. And basically, you have to see, are you even eligible to take it? You got to make sure that your employer is required to provide it. And the only times that the employers are required to provide it is if they have 50 or more employees within that 75-mile radius of their business. Number two is that if you have been in your employer's employment for either 12 months and you've been working a total of 1,250 hours. So those are the calculations you have to consider. If you are a public agency or school or state, local or federal employer, they have to provide FMLA. And if you think you are under those factors, then you are entitled to a 12-week unpaid leave.
So basically, like a lot of people think, oh, it's just 12 weeks I can take off because my employer has to give it to me. You just can't take it off because you want 12 weeks off.
Right. I wish that would be the case, but actually there is a requirement, and we'll talk about all those requirements in a bit. But number one is to provide your employee notice. And if it's a condition that is foreseeable, if it's a surgery that's foreseeable, for example, or a pregnancy that's foreseeable, typically it's a 30-day notice to the employer that you're going to take the medical leave, and the employer will have to make a determination that that condition is under FMLA leave or rights, and then they will have to cut that absences from the FMLA leave. So there's a lot of notice provision. Now, if there is, for example, an emergency, you got in an accident. I have some cases like that. You got in an accident, you were seriously injured, and obviously that's not foreseeable. So on that case, you have to give your employer reasonable notice, which is typically 2 days from the time of the incident, 2 to 3 days. So you have to provide some notice. Otherwise, there won't be a determination for the FMLA leave.
Yeah, it was an accident, and I was in the hospital for 3 days, then home, then back in the hospital, then home total for 2 weeks till I could not stand being at home anymore, and decided whether they said I could or not, I have to go back to work because I'm bored.
Right.
But my employer told me, we're going to charge you the family medical leave rather than you taking all your sick days because in our corporate policy, you still get paid under family medical leave for the first 2 weeks of your full salary. Then it goes down as each week goes along. Like that way, we'll save you from taking all your sick days. You'll still get paid for your time off. So we just calculated it that way.
Yeah, they can absolutely do that. And in fact, a lot of employers require that when you are in an FMLA leave, that you use your vacation or sick days, which is probably beneficial to some employees wherein they're paid for that FMLA, but they can't, in a case that is foreseeable, the employer have to give you a written notice that they will be using those sick days or accrued vacation days against your FMLA entitlement. In a case of, usually if it's foreseeable and they didn't give you a written notice, they can't retroactively say, oh, I'm going to use that against your FMLA. There's only certain exceptions where you can retroactively say, okay, I'm going to use it under your FMLA. Either it's an emergency situation, and then they have to give you notice during your leave, and that's pretty much it. It's in emergency situations. But if it's foreseeable, they will have to give you some sort of a notice to do that.
Who is considered an immediate family member in the eyes of the law when it comes to FMLA?
Well, that's the spouse, children, but basically any children that is above 18 years old are not immediate family member. The only time that they are considered immediate family is when they are disabled to the point that they can't take care of themselves. That's the only time. Parents are also considered with it. Now, a lot of questions come to me and say, what about same-sex couples at this time? Obviously, the Family Medical Leave Act is a federal law. And as we all know, because of all these arguments we have in the Supreme Court, the federal law only recognizes marriage between a man and a woman. So the FMLA does not apply to same-sex couples. You cannot unfortunately, you cannot take leave to care for your same-sex partner at this time. Even if, let's say, you're in Massachusetts where they recognize same-sex marriage, the FMLA does not apply to that. So just parents, spouse, and children under the age of 18 unless they are disabled.
I would imagine a lot of employers, though, give you a little leeway depending on what the situation you find yourself is and depending on how crucial you are to being there every day.
Right. And the employer got to be careful when they do that, because once you start making exceptions, once you start giving leeways to your employer, then you will have to do that for each and every one. Again, we have the discriminatory policies now. I'm not just talking about race, but discriminatory or arbitrarily imposing policies. If you start making exceptions and again, we have nepotism laws, and if you make an exception because your employee is a family member or close to you as a friend, then you might be dinged with the discrimination. Right. So you got to be careful when you do that.
Can my employer tell me like 7 weeks in, you know what, I need you to come back to work. You've got to come back.
Yes and no. Yes and no. And one of the things that we are looking for is the employer does have the right to request medical certifications. They absolutely have the right to do that. They can request a reassessment of your condition and make sure that you are still with the existing condition that is existing at the time you took the leave is still existing. So, in fact, a lot of employers will require you to undergo through independent medical certification. So you have your own doctor telling you that you have this serious illness, but the employer will require you to go under independent medical certification of a doctor of their own choice at their own expense and say, okay, I want to make sure that that's exactly what's going on. And so they can do that. And if they think that you're not, if you think there's some false representation of your leave, or if your condition is no longer existing, that is the only time they can call you back. But they can't, if everything else is true, if everything else is valid, they can't say, come back, I'll give you a lighter duty. That is absolutely a violation of the FMLA. And one of the cases I have encountered is on Facebook. So this guy, internet is such a, either it's a good or a bad thing, but basically this guy took an FMLA leave because of a serious back condition. But obviously, since the employer is a Facebook friend, he's posted vacations on pictures of that, doing all these activities. It doesn't look like he still has a back condition. So on that event, he's called back and say, okay, either you provide me a medical certification or your FMLA leave is gone. And now you've falsely represented your FMLA leave, so we can terminate you.
All right. We didn't get through everything on this.
No, we never do. We never do.
Airene Williamson, you can be reached at your office if people have more questions at 608-4072 or by email at info@wlawoffice.com.
Right. And for next week, we're going to talk about legal issues facing business owners.
All right. Attorney Airene Williamson from the Williamson Law Office. We will talk to you again next Tuesday. Ray Lucia coming your way next on News Talk 720 KDWN.
Over the past year, we've saved Nevadans over $2 million on auto loans. You can save too. Refinance your auto loan with us today, and we'll even throw in no payments for 90 days. But hurry, the sooner you call, the sooner you save. Visit us at onenevada.org today or call 457-1000. One Nevada Credit Union, federally insured by the NCUA Equal Opportunity Lender.
The answer to our nation's economy lies in our rural areas. All the building blocks that we need to bring our nation back are in those rural areas. Tune in to Rural Nevada Today every Saturday morning from 6 to 7 and learn why. Listen to our show anytime by going to our website, ruralnevadatoday.com.
Hey, it's Rusty Humphreys. Catch me today at noon and catch my friends John Burnett and Elisa Grassi on Daybreak Vegas weekdays at 5 a.m. right here on KDON, where no